Thank you, everybody, for being here. My name is Chris Bavitz. I'm a clinical professor here at HLS and one of the faculty co-directors at the Berkman Center for Internet and Society, and I am honored to be moderating this afternoon's panel about law, technology, and privacy, which, when I was talking to Karen about what the scope of this panel would be, and she mentioned that as the title, I said we probably need about a semester, and she said you have 90 minutes. I said, all right, we'll do the best we can. This is the broadest possible topic, and we're going to come at it from a number of different perspectives. And I'll just tee this up by noting what should be obvious to everybody in this room. We run a clinical program here. Dalia, Ritvo at the end of the table, and I run our IP and tech clinical program here. And I've been here for almost 8 years now, and privacy has always been an issue that's on our docket. But at this point, there is a privacy angle to virtually every project we do in the clinic. Our clients tend to be startups, nonprofits, arts and cultural organizations, others who are doing interesting and innovative things with technology, and whether they're scanning big data or developing new tools to allow people to communicate with their doctors or advocating about search and seizure in the Fourth Amendment from a civil liberties perspective. There's obviously a huge technology and privacy hook to all of that. So we're going to talk for a bit, and we're going to save plenty of time for questions at the end. And rather than my trying to go down the list and read all of the accomplishments of each of our speakers, I'm going to ask each of them to introduce themselves and maybe talk for a minute or two about the perspective they bring and how privacy issues intersect with their work. And I think we will be talking today about privacy again in all its dimensions, and to kind of frame that in two really big ways. I think there are people here on the panel who think a lot about privacy in terms of surveillance, in terms of government, privacy vis-a-vis the government. There are folks here expert on issues related to privacy vis-a-vis private companies, the relationships we form with the companies that store our data and our documents and our emails. Hopefully we'll have time to touch on all of that. So I'm going to turn to Susan, if that's okay, and ask Susan Freiwald to introduce herself and, start us off.
All right, so I'm told I'm supposed to introduce myself, tell you a little bit about my milestones in my career, and then tell you about my perspective. Yeah?
Beautiful.
Right?
I love it. This
1 minute
great.
each, okay?
Yeah, let's do it.
All right. So I teach law at the University of San Francisco School of Law. I've been there about 20 years. Before that, I clerked and worked on Wall Street for a little bit. And so I teach cyber law, which has now become internet law because cyber law is no longer a cool word. And I teach privacy law, and I used to teach contracts, but after some retirements, I have now taken over criminal procedure, which is my love. And I've been writing about communication surveillance of new technologies for a long time. That's mostly what I've been focused on. And so mostly a lot of scholarship, and then I was actually in the last couple of years able to get involved in some actual cases, and I worked as an amicus or amicus, whichever you prefer, in a case involving the first recognition that email deserves Fourth Amendment protection. So that was called the Warshak case, and I co-authored the law professor's brief in that case, and then I went on from that to work on some amicus briefs in cases involving access to stored cell site location data. And from interesting, it just happened that there were no identified targets in those cases. So the amici, which was me and some civil liberties groups, were able to argue those cases. So I argued a case in the Fifth Circuit and a case in the Third Circuit. And so that was a career milestone. And then after that, I worked on, I've been involved for many years in reform of the electronic surveillance laws at the federal level, many years. We actually may be making some progress next week, so hold your breath. And then last year, I was the academic liaison with a coalition effort in California. We actually passed a law in California called, we call it Cal-ECPA, SB 178, and it brought significant reform to the standards for law enforcement access to device data and data stored by service providers, so metadata, location data, and content data. And I can tell you more about that if you have questions. Oh, and my perspective, I'm a civil libertarian who has a technical background, who's grown increasingly convinced that it's a really complex issue and we have to keep account of all the various interests, including public safety.
Thank you, Susan. Julius?
Great, thank you. So I guess it's been 25 years. I've spent most of that 25 years around tech media telecom, 15 of those in the private sector, most of that helping build a company that's associated with Barry Diller called IAC. We owned and operated businesses like Expedia and Hotels.com and TripAdvisor and Ticketmaster and Match.com. Lots of fun. I'm at the Carlyle Group now, investing in tech, media, telecom. I spent 10 years in government, so 15 in private sector, 10 in government. The bulk of the government years at the FCC, and I was lucky enough to spend 4 of them as chairman of the Federal Communications Commission in the first 4 years of the Obama administration. So with all that background in tech, media, telecom, I should know something. It's one of these areas where the more time you spend in it, the more you realize that it's so fast moving that it's actually hard to get one's arms around any of the issues. I think Chris is right, and Susan really said the same thing. But I'll try 3 thoughts coming out of both my private sector and government experience. So one, as a general matter, subject to exception, people in government misunderstand and oversimplify the private sector, and people in the private sector misunderstand and oversimplify the government. Point 2, public discussion around all of these issues, tech policy in general, has gotten worse and is pretty bad. The weighting of bumper sticker debates versus substantive discussion, it's never been great, and as long as I've been around this, but it's particularly bad now for a whole bunch of reasons we can talk about. And then the third point is, at the same time, these issues are taking on greater importance. Technology has always been important. Information communications technology has always been important. And it's always been true that technology in general, ICT in particular, can be used for good and for bad. And we kind of have to figure out as a society how to maximize the good and minimize the bad. The challenge today is that the magnitude of the good and bad is getting larger. The velocity of the issues presented is speeding up, and the complexity is increasing. So these are all, a bunch of good reasons to be a pessimist. I'm just inherently an optimist. CEG thinking in 2007 that Obama could become president, so I am an optimist in this area. And one of the things that gives me optimism is something that we saw today at lunch. I hope all of you had a chance to see Jonathan Zittrain, but the kind of thinking and work going on here at the Berkman Center, it is something that gives me optimism, and it's the kind of thing that if we could figure out how to extend those kinds of discussions, that kind of thinking to a broader audience, we'd be able to make faster progress on some of these hard issues.
Great. Horacio, who spent a very long 5 days as general counsel of Spotify this week, so
yeah.
Turning it to you.
We can talk all about that. I don't know if 90 minutes is going to be enough. I might be the only person here who actually did his JD after the LLM program. If you're in my camp, raise your hand, but I did. I came to Harvard, did my LLM degree, and then went back to my country and then returned to the US to get a JD and then have a practice. I spent 18 years until Friday of last week at Microsoft in a variety of positions in the legal department, both in the United States and in Europe, and more recently as general counsel of Microsoft until a week ago, and then started at Spotify as general counsel on Monday. I don't know how much I can share in terms of perspectives of my new job. I'm lucky if I remember my new password and how to log on into the system. But there are some things that are very common between the two, and issues that we have to talk about and that we hear about in the media all the time. And it's this notion of privacy and public safety and privacy and security, and which one are we going to pick? And are you with Apple, or are you against Apple if you're not with them? Or are you with the terrorists otherwise? And will the terrorists win if you think about privacy? And that is the central question of the technology policy discussions of the day. And we know that it is never that simple. And in fact, even before technology, this tension existed. That was the tension that led to the Fourth Amendment, those very discussions about privacy and public safety and public order and things of that sort. The question is, how do those principles that were so carefully developed in the physical world are going to translate into the online world? And when you look at it from that perspective, you know that the answer cannot be that privacy will always trump security, and you know that the answer cannot be that security will always trump privacy. The reality is we as users, we want everything. We want privacy, and we want security defined in however we think they should be defined. And that's a fascinating discussion, and it's one that permeates what's going to transpire in the courts in the next few years. It's what's behind Director Comey's of the FBI statements and the New York Attorney General statements about what's going to happen with the iPhone. But these are also questions that are being raised in other parts of the world by governments who are watching very keenly how the conversation takes shape in the United States.
Great. Turn over to Gönenç.
Hi, I'm Gönenç Gürkaynak. I'm the class of 2001 LLM. I'm the founding partner and the managing partner of one of the leading law firms in Istanbul. I formed this law firm after I practiced in New York, London, and Brussels, qualifying in these jurisdictions. And then it grew into its current size of about 100 people now, some 75 lawyers. And we predominantly do regulatory work, so there is some transactional work too, but our main thing is regulatory and compliance, and internet law is a large chunk of that. And Turkey is a country with significant security concerns and issues, and Turkey is also a country with a hardened society, which means that you have to always deal with borderline cases. Things can be dressed up as privacy concerns. Things can really be privacy concerns. So it's a very tricky jurisdiction from that perspective. I actually am a student of law and economics, and my really main area has always been competition law. And Google and Twitter and Uber and AT&T and whatnot have drawn me into this field of law. So I had to learn it by doing it, and by being a part of it, by molding the legislation while it was being promulgated in Turkey. Just last Wednesday, the data privacy law has passed in Turkey, and I was lucky enough to be one of the lawyers providing an opinion and shaping it, although it didn't pass the way I have hoped it would, but it never does, so that shouldn't be a big problem. So ultimately, I'm really looking forward to this discussion. Also, it's a great honor for me to be in this panel, and Horacio has also been someone that I have worked with quite a bit, because while I was in Brussels, I was defending Microsoft together with the rest of the team, and he was the in-house counsel at that time coordinating, so there was some Harvard class solidarity there, and I'm happy to find that opportunity again.
That didn't go too well, though.
No, yeah, we didn't succeed ultimately. I fled to Turkey, actually.
Dalia?
I'm Dalia Topelson Ritvo. I, as Chris mentioned, am the assistant director of the Cyber Law Clinic. We've held on to that now passé term, mostly because it confuses most people. And I started my career at New York law firms as an IP attorney, and then started as a litigator, moved into a transactional practice, and then went in-house at Amazon. And during that period, software went from a licensed model to a software as a service model, which transformed the issues that we grappled with just from a business-to-business perspective. Suddenly, the IP licensing issues became minimized and the privacy issues became maximized. Who is the custodian of data? How is data flowing? Who holds it? How protected is it? Is it secure? Who can capitalize on it and make money off of it? So all of these issues started to percolate. After Amazon, I came here and joined the clinical program here at Harvard, which has been an excellent experience. And the privacy issues have only ballooned. More recently, we have a pretty robust practice at the clinic dealing with student and children's privacy, which I consider a microcosm of the privacy issues that flow through the marketplace right now. It really reveals the tension between, venture capitalists seeing it as a business model to collect and utilize and capitalize off of data, the needs to protect children and profiling children, et cetera, and how that impacts them as they develop through their education and enter into adulthood. On top of the needs and the uses and the positive uses of data, both for research purposes, for development purposes, being able to create innovative models for individualized learning, et cetera. And all of these things can be overlaid into the general population. Add into that the surveillance issues that play into this in the microcosm I'm talking about with students. It's the schools, it's the teachers, it's the principals, it's the parents, and how much access should they have, what rights do the individual students have. Take that into the consumer world, it's now government, it's law enforcement, and the tension between the need to protect consumer privacy and do right by your users in that respect, and also the needs of law enforcement to prosecute real crimes, serious crimes, and how does that interplay? Obviously right now in the news, it was highlighted very well by the Apple encryption battle that has been going on. So all of these issues have kind of coalesced. I would say I'm more on the consumer privacy side, but more and more I've been involved with working with companies and private organizations and how to handle and protect their users with respect to government requests while also being very respectful of the law and understanding where those lines are and when is it appropriate to push back and when is it appropriate to actually give over information, and how transparent can you be about that, which is challenging, particularly when you talk about the most serious crimes that are subject potentially to covert investigations, et cetera. So I never thought I'd be in this field, and now I'm steeped in it. I find it fascinating. I tell all my students they should go into it, but we'll see how many of them enter into it.
I'm struck by a lot of what has just been said. Maybe I'll start with this, which is the incredible magnitude and complexity of this space and the incredible magnitude of these security versus privacy, privacy versus privacy, security versus security kinds of debates that I think Susan and Horacio alluded to. And then Julius's point about the fact that public policy debates generally in this country have been reduced to sort of bumper stickers and slogans. And this is not a space that lends itself well to bumper sticker length debates. Given that trend, which I think we can take as something of a given, how can we expect to have any reasonable conversation about these issues, reasonable regulation in this space? What can we do to engage people so they understand the magnitude of some of these concerns? Is a big question, but how do we deal with that tension?
I can take I'll take just a crack at that, because I think it's always useful in these things to take a step back and look at things in historical terms. These principles that led to the Fourth Amendment and how the Fourth Amendment has been interpreted in the U.S. over the years, that did not happen overnight. That was the result of many years of case law, of the evolution of the legal thinking, and then the application of those principles in individual cases that created, the distinctions that were necessary. I know right now we live in this society of instant gratification, and we want to have answers now to everything, and the answers have to fit in 140 characters. But that is not the way these difficult constitutional and policy questions are going to be developed. So the frustration stems from the fact that we're looking at this snapshot of time right now, and the reality is it will take years for these things to play out and to evolve. I think the most important thing on the policy front is to to try to have the discussion where it needs to be. There is a policy making and a legislative discussion that needs to take place in some respects. And then there will be cases before the courts that will shed some light into that issue. The main thing is, and I know this is not very popular, but cyberspace is not its own thing, immune from the laws of gravity, where legal principles can't really penetrate. It turns out that the same principles that work in daily life should apply. I'm not saying they will apply mechanically and immediately and in an obvious way, but some of the same balancing of principles and values that are important societal values in terms of public safety and security and privacy and all those things apply the same way in that world and in others. And that is why it's not a really good discussion to have over the media, over the Twitter sphere or others like that, because it requires a level of nuance that is not welcome in that space.
Yeah, and I'd just like to follow up. You know, one way to have this conversation is through the involvement of all the branches. And so, for example, with Apple versus FBI, when this question was percolating before FBI found another way in, there was a question of whether the court should get involved in the question and resolve the motion, or issue an order. And some legal academics put together an amicus or amicus, whichever you choose, brief, and the basic thesis of the brief, or one of the big arguments, was the court should stay out because it's such an important policy question that it should be resolved in Congress. Well, meanwhile, of course, Senator Feinstein and Senator Burr were rushing to get a bill through that would have, just ruled out any kind of encryption that wasn't immediately crackable by the FBI, which I don't think was a particularly considered approach. But I didn't sign the amicus brief because I thought it was important that we hear from the courts on the question, and that in general, I think we get the best answers when the courts and Congress have a dialogue about surveillance. And one of the problems we have in the surveillance area, for example, is that too many of surveillance practices happen behind closed doors without oversight by the courts. And so then you just really get the executive branch making those decisions all by themselves. So one of the principles I've argued for in my work is more oversight through notice and through a warrant and through suppression remedy, which I know is controversial. But I think, apart from the Twitter dialogue and all that stuff that you're always going to have, I think our system works best when we have all the branches involved.
And
Go ahead, Gönenç, and then
I would just
Dalia, and then Gönenç.
quickly add, from the consumer side, what has happened with major tech companies becoming custodians of vast amounts of data about individuals and very sensitive private data about their day-to-day lives is that there's a disconnect between citizenry and government in this regard, which is highly problematic, and it's putting companies in strange positions of almost being policymakers themselves, which, in my opinion, is not the appropriate legislative process or even judicial process, because companies should not be arbiters of these questions, and nor do they want to be very fair to the companies. But I think there needs to be a little bit more education with respect to just public perception and understanding of these issues, which can be presented in a very dry manner. I'm loving John Oliver right now for putting these at least to a small demographic in a way that people kind of wake up to these concerns so that they can speak to their policymakers about these issues, because these questions are no longer being handled between the citizenry and government. They're being handled between companies and the government, which creates potentially poor policy that doesn't protect the individuals that ultimately we're trying to attend to.
Gönenç?
There's, of course, an emerging market perspective to be developed for this, because most emerging markets lack the decades of precedence and the maturity that Horacio was talking about, which really has a bearing on the entire analysis. So what happens is typically you end up with the police officer wanting his video of attacking journalists during a press conference be taken down for privacy reasons. or you end up in instances where there is absolutely no privacy expectation. That privacy is being used as an excuse for something else, and that is not too far from censorship. I'm not saying there are never genuine privacy concerns, but privacy is always a concept where you raise an eyebrow in most emerging markets if you are a proponent of freedom of speech and if you want to take a hard stance on making sure that people have access to information. So there, I think we are in a very delicate situation because these emerging markets have to explore their potential. And the only way that they can really explore their potential in a sustainable way is if they become freer. And for that, the internet and especially information of all kinds is extremely important because potential is not always there to stay. I mean, I think a global phenomenon is that whenever anybody talks about an emerging market, a developing economy, that person would say the word potential, a lot of potential, tremendous potential, full of potential. That can be said for the class of 2011 here, but you can't say it for the class of 86 here. If you're still talking about potential for the class of 86, there's something wrong with the class of 86. That's the same thing. Sorry, I know. It cannot be said, I said. So, I think
sometimes freedom of expression is not a good thing.
So the point is potential is to be realized, and it fizzles out, and there is a time period. All right, 86, 91, fine. Sorry.
Wait, that's me.
2001. So wrapping up, I think my point is that the potential that needs to be explored has to be explored only through more freedom of speech, especially the nucleus of all ideas, there being a free market for ideas, the better idea prevailing, and that inducing innovation, and that innovation bringing forth the society. And ever since I have written a book that was published in Turkey on innovation and the law, I've been a fanatical of that, so much so that sometimes people mock in Turkey the innovation crazy lawyer is here again. But innovation is the true engine of all growth. So bottom line, I think privacy means a lot, and it's very important, and it is a new generation concern that we have, that we should have, for reasons also explained by Zittrain during the lunch conversation. But if we don't become skepticals of it in the emerging markets, we may be losing out on very valuable juice for the society that we can never replace, and that potential is not there to stay. So we may actually see certain emerging markets that are not realizing their true potential in the global economy.
Gönenç talked about the emerging markets perspective. Another perspective that I think is really relevant to consider here is the international perspective. We're talking a good bit about U.S. law on privacy, but there's a global dimension to this. There's in particular, I think, relevant to the expertise we have on this panel, an EU-U.S. dimension to this. And I'm wondering, as we think about investing in companies or advising companies that have to deal with these very different legal regimes, extraordinarily diverse approaches to privacy regulation in Europe, where I would say it's very highly regulated at a very specific level, and in the U.S. where it is less regulated, but for in a couple of very key areas like student data and healthcare data and that sort of thing. The U.S. First Amendment obviously plays a big role in kind of how the U.S. has developed its own jurisprudence around privacy. How do companies that are doing businesses in multiple jurisdictions navigate this landscape? If anyone has thoughts on that.
With difficulty.
Yeah.
Look, there's a part of this that's a reality that we have to accept, and that is that this difficult balancing is a reflection of societal values that may vary from country to country. Now, privacy and the respect for privacy is a fundamental right. And it's amazing that some people cringe when they hear that privacy is elevated to that, but it is actually in the Charter of Fundamental Rights. It's in some of the international instruments, and it's obviously in European legislation also enshrined. But it is not absolute, and the instruments also recognize a number of exceptions. So that really means that the individual way of balancing some of these values allows for some flexibility on a country-by-country basis. For a company that's doing business around the world, and that was the case when I worked at Microsoft, and it is increasingly the case at Spotify, there's a part of this that just requires a lot of work, and it just requires having good lawyers and having an infrastructure so you understand the practicalities of how to do business there. And then there is the problem that there is a limit to how much you can continue to have the value of a global internet if every country regulates the service in such a way that it loses the advantages of this global platform. So once again, it is a matter of balancing these different things. So we are still at a stage in which we are in an advocacy stage, an opportunity in which policies are still in the process of being formulated, and where there is an opportunity to advocate for harmonizing regulatory regimes. But we are going to see situations like we see today between, conflicts of laws between the laws of Brazil and the U.S. and the laws of Luxembourg and the others, where, companies are being put in a position where if they comply with a law enforcement request in one country, they're going to be, by doing that, violating the law of a different country. And those are the anomalies that will have to be worked out as we recognize that these are, by their nature, global services.
Yeah. I would just add a couple of things to that. As complex and challenging as the U.S. policy issues are, when you blend in the international issues, it's a whole multiple additional layers of complexity. A couple of points. One is, one of the ways that the technology world has shifted is that it used to be that internet companies started as domestic companies, established their market position, and then thought about international expansion. That was certainly the case in the U.S., and you could think about Spotify the opposite. But that's not the case anymore. Modern technology companies from day one think of themselves as global companies. I think that's very healthy. There's some issues around that in terms of where jobs end up being created and what that means. But that's point number one. Point number two is, on one hand, it's healthy and valid to see experimentation around the world on policy. At the same time, I think there's no question that we're seeing around the world many different countries use either privacy or security or both as covers for protectionist policies that are really designed to protect local industries. And whether it's a young internet company. I'm fortunate to be on the board of MasterCard, which is a global company, and sees this around the world. That's a real challenge. And the other real challenge in the space is, in addition to sort of protectionist policies posing as security and privacy, is the extent to which the internet will remain a free and open global platform. So some countries are moving forward with privacy or security policies, and they're really designed to protect local companies. Other countries are moving forward with actions in these areas, and they're really designed to suppress local information flow and discussion and to censor. And unfortunately, the stronger the privacy and security imperative, and they're very important issues, but the more cover that actually provides to countries around the world to take steps that are counterproductive for free speech, free markets, and a flat world. We all have perspectives on whether a flat world at the end of the day is healthy or unhealthy. I take the view that it's healthy. But it is a really important issue, and I think all of us in different things that we do have seen it.
Very small addition to that. That's great. Thank you for that. Basically, it's so true that something that happens marginally in these kinds of fields in developed countries has such a bigger ripple effect in the emerging markets. And you could use any kind of analogy. I mean, if Harvard Law School did not use the good sense of the dean and allow for those signs to be there still, reclaim Harvard signs and the freedom of speech that is going on in the Kasperson Center now, I bet you dozens of schools all around the world would have said even Harvard Law School is taking it down. So things set a precedent very quickly, and of course, being a part of a nation that is already developed, you can't take your policy decisions bearing in mind what this is going to mean in other parts of the world. But then again, it's a global gameplay now, and to the extent a hardliner approach is being produced about calling everything privacy, for example, you can bet on it that that's going to be a term that is used very frequently in Turkey, to the extent you come up with the right to be forgotten and not define exactly what it is. The elusive term of right to be forgotten is suddenly turned into, I should have a right to be forgotten. I just went for severe corruption issues 4 years ago, and I'm a politician, but I want to forget this. Don't you want to forget this? So, it's always going to be that kind of a situation. Therefore, we need a global approach to these kinds of things, both in academia and in the legal practice, I think.
But at the same time, with a global approach, you do sacrifice the fact that different countries approach questions differently. So, for example, Europe treats dignity as much more important than we do here. They put a value on it. And related to that, when the European Court of Justice rejected the Safe Harbor Agreement and said that it was that the U.S. didn't provide adequate protection to European citizens' data because of the Snowden revelations that showed that our national security apparatus was getting too much unpredicated access, so mass bulk access, thank you. Bulk access to European data without really any recourse for the Europeans, and that therefore we couldn't just, U.S. companies couldn't just access European data under the current terms of the Safe Harbor. And they made that decision, and it wasn't, and I don't know if you were, Julius, if you were referring to that decision or not, but it was not, my understanding is that decision was a reflection of very different European values, of an approach to service providers, particularly Google and others, that they had an obligation to further dignity and not just to make money, that they had some responsibilities that we would never impose on our own service providers, and that the European Court of Justice acted very independently of both the trade representatives and even the national security apparatus in those countries, who on their own might have wanted a much more cooperative relationship with our national security people. So on the one hand, it was a very disruptive thing that they did. And it was, I don't think it was for protectionism. I think the European Court of Justice was just doing what they wanted to do. But I think that, by asking for, let's all see the First Amendment the same way, or let's all, have the same values, you lose something which is called, there's other ways to think about, how to treat intermediaries, how to treat your big companies, how to treat dignity, how to treat human rights. And I think that's something we need.
Horacio, I don't know if you have other thoughts on the safe harbor specifically. We've talked generally about it, but that's obviously a very hot topic. It seems like the regime, the pre-existing regime that had been around for a while, was struck down. A new one seems to be in place or coming into place now.
Yeah, I'd have to say that I spent close to the last 4 months of my life at Microsoft speaking of little other than this, until the Privacy Shield agreement was announced, and we'll see where that goes. A couple of reflections on that. The one is, the high-level reflection is it really served to remind us how important data and data mobility is, the significance of data flows. I mean, if you looked at the scenarios that we were building, not only for ourselves, but for the industry, just the pain associated with having to change the business in a way so as to prevent data from flowing from Europe to the United States would have been incredible. And I don't mean just for the company or the service providers, for the users, for the customers of companies that use those services. Just imagine travel reservations where your passport information cannot be inputted because it has to go to the other place where you're going to make a connection. Just basic scenarios that we take for granted today would have really been broken. Not to talk about the billions of dollars that it would have taken to really re-engineer the services and the inefficiencies that would have been created just so that you could replicate the collection of data and keep them separate. So essentially the lesson of this is, and it's going to get even worse with machine learning and big data techniques and all those things, resistance is futile. Technology has taken over so many of the tasks that we take. Data is essential, is going to become the currency of the future in commerce, if it's not already. Internet of Things and ambient technology and all those things, the intelligent agents that people are talking about, some of them exist today in some rudimentary form. The scale of data collection and the questions that it will raise from a legal and policy perspective and even from a digital sovereignty perspective, I don't think we have even begun to appreciate what those are going to be. This is just a preview. Safe Harbor was. Mm-hmm. And the other thing that I would say about that, and just commenting on the remark made previously, it is interesting that in Europe, the Court of Justice made that decision, and it was really, I would say, mostly a reaction to the revelations in Snowden. So much of the debate you see today are really second and third order effects of what I think people can say was an overreach by security agencies in the collection of data. I think it's fair to say that. So one has to put those things in that context. That discussion was also devoid of answering the question, what do security services in Europe do? When you're making a determination that the American system is not equivalent to the European in terms of the protection that it affords citizens, is the European security system behaving any better? And that question was never had to be answered. To this point, hasn't been answered, and it shows how sometimes these outcomes are the result of one side of the equation taking, the mantle and speaking, and maybe at a different time of the pendulum swing between security and privacy. It'd be interesting after the attacks, the unfortunate attacks in Europe, what is the reaction? Is privacy now at the center, or is now security and public safety more at the center? We've seen that pendulum swing in the United States in terms of public perception. So at a high level, I think what it was is a reminder of the fact that we live in a world that is dependent on the flows of data around the world, and also that these policy questions are really dictated by the unique perspective that a society has at a particular time. And those may change.
Susan, do you want to?
Well, yeah, I mean, I understand your argument, Horacio, but, you said it would be so expensive for the user, who I think would be the European user, who wants to take advantage of Microsoft, because Microsoft would either have to put up barriers so that they treat European data so much more protectively, by complying with European rules, than they treat American data, or that was one choice, or they would have to maybe go through a European business and not an American business. A third choice is that Microsoft, raise the privacy that it delivers both to Europeans and Americans, which to some extent has happened, and I think you see it, the Apple case is an example of it. But if I could finish, I think that's one thing. I think that we're moving away from a time, and I see this with the FTC and with the FCC and with European pressure, where where we regard as the public interest the interests of the big corporations. And one last thing, and then of course you'll want to respond, is that I do think we're also moving into a time where we used to think that data was just an asset. And the more data, the more valuable. And I think we're starting to recognize that data is a toxic asset in some ways, particularly because of identity thievery, which has just gone outrageous. And that companies really need to pay attention to how much they're collecting and whether they need it and whether they need to store it and how they store it. And I think we're seeing a real shift that's important. And just, because the information that companies collect can be very dangerous. And then it can go to the government very quickly and very easily, and that in itself can be dangerous. So you recognize a problem with overreach by the NSA in terms of bulk collection, but it's something that companies are doing too, which then is available to both law enforcement and to the intelligence agencies.
There is always a way of presenting these things in a manner that sounds nefarious. When you look at the use of data from the point of view of the value that the consumer gets, and I'm not speaking on behalf of a company here. I'm speaking on my own. We've become so accustomed to the fact that we have these services that wherever we are, we can make travel reservations, we can make changes, we can. I can wire money to my daughter who's in college from the train or from wherever I am. My comment about what would happen with the collapse of Safe Harbor if there hadn't been an agreement that would succeed had nothing to do with what the company would have done. It was not just the matter that the safeguards that were in place in the U.S. from a corporate perspective were not the same. In fact, they were exactly the same. The concern behind the European Court of Justice decision did have nothing to do with the behavior, had nothing to do with behavior of companies. It had to do with what they call the generalized collection of data by the security agencies. So, in fact, reputable large companies have infrastructure in place to protect the data, and it would be impossible to treat it differently generally from one jurisdiction to the other. So essentially, the high watermark sort of governs the way data is managed. And the point about the second remark that you made, absolutely everybody recognizes the risk of holding data. And it also, companies recognize that in the online world, trust by the customer is essential. If the customer doesn't trust you, they will not provide you the data, and you will not be able to serve them. But there are different kinds of services, and people have different tolerances in terms of how they expect the service to treat their data, depending on how sensitive the data is. But the reality is that when you think of the value that these services can give you, how they can personalize, just imagine a personal digital agent that's anticipating your needs, and it's telling you, like it does today, if you want to get to that meeting in downtown New York, you better leave now because I just checked traffic and it's terrible. And by the way, if you want to get to JFK for your flight at 5 p.m., you better do that. And did you have your passport? Do you remember to do this? I may be describing it a little bit more annoying that it is or not. But just imagine the value into your daily life that technology can have if it just can know enough. Now, the problem is, what if it doesn't work the way it's supposed to work? What if you can't trust the people who have that data? What if it's hacked? What if someone can then reconstruct your whereabouts and know your location at every time by just tapping into the data of it? That's, these are the pros and cons of these things, and as usual, we're going to have to make decisions as to how much do we trust these services.
I did one note to that. It's an interesting question on both the private sector side and the government side, when things are self-regulating and when they're not. And so, there have been a number of significant security breaches over the last few years, Target and some others, and CEOs have lost their jobs. And that is having a self-regulating effect at companies. There's no board that I'm on, no company that I'm engaged with that isn't saying, hey, wait a minute, that can't happen to us. And that's a healthy thing. On the government side, it's a healthy thing. A question is whether it's sufficient. Right? You could take the view that everything will be self-regulated and government doesn't have to do anything. I don't think I'm convinced that that's the case. There's a similar issue on the government side. The Snowden topic has had very negative consequences for the U.S. government, and the U.S. government thinks so, for U.S. companies, and U.S. companies feel it. And we're going through something of a self-regulatory reaction to that. We'll see how it plays out. I think the challenge, whether you're on the private side or the government side, in advance of something going wrong where self-regulation is required, is how to think about some of the technology trends in advance and try to get it right in advance. So an interesting example is what's happening now with Internet of Things and voice activation. Right? So it's already been the case for some time that your phone is listening to you almost all the time. And we see now with the success of Alexa, Amazon's product, that people actually really do feel the benefits of, oh, wow, if you haven't tried it, I encourage you to try it. It's very interesting. I'm on the board of a company called Sonos, and you'll see it happening there as well in the music space, good partner of Spotify.
Sonos is great.
Sonos is great. But imagine now, all these devices, our phones, other devices in our homes that are listening all the time. What's going to happen here? Will it happen that something will go wrong and some company won't adequately protect data, or there'll be a hack, and then we'll have to go through, a pretty awful period of self-correction? Or can companies, the government, to the extent it's appropriate, get it right in advance and say, hey, listen, we see the dangers, we see the risks, let's get it right in advance. And it's kind of a thought experiment. We'll know in a few years whether we have learned the lessons from the private sector and the government mistakes of the past and have gotten it right in these new technologies as they develop.
Gönenç, do you want to follow up?
Yeah, I think there's a broader policy question in these fields, which is what are we trying to do as mankind or as human beings? And really, these discussions are really going into the very heart of it. When you're discussing criminal law or real estate law, you're trying to govern something about your coexistence. But with this, you're dealing with something that grows exponentially, that is information, and that takes you from one place to the other, and there's a lot of unknown. You thought you would map out human DNA in decades, and the more you map it out, the more you realize, oh, now I'm learning how to map it out, so suddenly I realize I'll be doing it way more quickly because information feeds information and it grows exponentially, and you're in that very delicate field. So I think it may be a bit aggressive as a view, but a part of this would better be regulated after the harm is done, in the sense that you can't look at Wright brothers and say, we need airline regulation. You'll have to have some plane crashes, you'll have to have planes flying around, and then realize why certain problems are coming about, and then regulate it. If you do it too quickly, and men is very prone to doing it too quickly, especially in the AI world. Go to the movies of 1960s, and you're already seeing people intimidated about the prospect of AI taking over, whereas that kind of AI is still non-existent. The AI that has a recognition of existence. I am machine, and these are people, and I am not them kind of existence. And we don't even know if it is ever going to be possible to give that kind of existential understanding to artificial intelligence. And yet we're discussing AI regulation as if things are about to tip. Or with data privacy, I do fully appreciate that privacy is very important, dignity is very important too, but one has to take baby steps. The Costeja decision of the European Court of Justice was not a baby step. It was a huge, sudden erection of a building on the concept of erasure. And if we were to take those kinds of huge leaps in one single shot, it's going to be very difficult to detect what we have done, whereas we should be testing it baby step by baby step by baby step, because we're in a very delicate field that has to do with all of our welfare.
Can I
which is
just one
innovation.
note on that? It's a very provocative point. Bad thing. Let's let bad things happen first. So while I agree that there's a risk to government regulating too quickly and incorrectly, I don't agree that we should wait for a drone to crash into an airplane before we try to sort it out. I think you're raising a really important question, which is, as the magnitude of the risks get greater, how do we run a government and a conversation between government and private sector and citizens so that we can get the balance right? And I think it comes back to something that we were talking about at the beginning, which is the dysfunction we have and our inability to have those discussions and those conversations. And I guess I'd make one point on this from my experience, which is there's so many levels at which one can talk about this, but I want to talk about it at the level of personal responsibility, wherever you are in the ecosystem. And I think one of the trends that I've seen is almost a divorcing of these issues from people and the roles they occupy, whether as citizen CEOs or government officials. It's hopeless. It's decided by someone else. My views, my input, my actions are not relevant. It's a very dangerous trend in a democracy and a free market, right? It's really essential that we all, in whatever role we play, think. I guess I'm preaching now, but I'll just finish. But think about what we ought to do in our lives to get these great experiments right. If we're a CEO or we're in a company somewhere. I thought Jonathan Zittrain really hit this today with the fiduciary duty concept. I thought it was a great frame to think about this. What's your duty as a CEO at a company? What's your duty if you're in government and you're tempted by various political considerations? But what's your duty? What's your duty as a citizen in a community? What's your duty as a parent as you watch your kids dealing with these devices? And we all, fail at this every day. But I do. I do. But I think it's a lens, and I was moved by what Jonathan talked about today, and how a part of it is everyone in their roles accepting the responsibility of a free society and looking at their actions through that lens.
And by the way, when one talks about regulation of situations like this, you can talk about actual regulation, or you can talk about it in terms of defining liability by the companies who fail to live up to whatever the standard, the duty of care is in a particular situation. And if you look at the evolution of the automobile, it was really a combination of both. It was essentially the development of strict liability standards by the courts, and then a whole body of specific regulatory rules that were coming down of government in terms of safety standards and things like that. And I am one who believes that the notion that there is a no-fly zone for regulation on the internet is really not realistic, and that there needs to be a dialogue as to what is the because what you can do is you can have really harmful regulation that would neither protect the consumers and at the same time freeze the innovation in some of these spaces that are really nascent, because you wouldn't even know. How do you regulate cybersecurity? This is a cat and mouse fight that is fought every day, and it is a technology battle. How do you even explain to a lawmaker or a regulator how to think about it? Some of these things cannot be regulated in that way, but liability standards and fiduciary duties and the definition of the duty of care, those are things that actually can develop over time. And I think it's worth having a conversation.
I will say, I do think that there are some rubrics that we can build upon to have these conversations. And the challenge that we're facing is the siloed conversations that are happening across the world. And that actually hinders innovation from the emerging markets, and it also hinders innovation just from the startups. It's the people at the table are the big 5 to 7 companies that we all know. But the other tiny little companies that are actually probably doing the more quote-unquote disruptive things and really pushing the envelope, they're nowhere near these conversations and aren't even anticipating it or thinking about it. The first rubric is international human rights. We do have international human rights rubrics that really think about how governments and even companies, with the Ruggie principles that were established a few years ago, deal with the tensions between freedom of expression and privacy. On top of that, there is this idea, and this takes a little bit of collaboration across the market ecosystem, including the funders, the companies themselves, the technologists, and even information scientists, to really think about how it is that we engage with our consumers and our users and how we treat and understand data. I think somebody earlier mentioned how data is often seen as an asset. I think that's the wrong perspective, and it's very rooted actually in an intellectual property regime, which doesn't really apply well and overlay well to data. When it comes to data, it's really about control and who's the custodian of it and who's the trust. Based just solely pulling it back from the international context, which can be very large and messy and difficult to think about. If you bring it down again to technology in schools, which is a much smaller place where people can generally agree, we like to protect kids. That's the one thing most people can agree on. So it helps advance the conversation a little bit easier. In that context, you're suddenly creating technologies that can create full profiles of individuals that have no agency. So if you think about an individual that has no individual agency, no individual rights, suddenly these questions bubble up extremely quickly. And how is that going to follow them as they lead their lives and as they actually earn and gain that agency? This is true of citizens. This is true of consumers. It's just not thought about in that context. And I challenge everyone at this table who attack this issue from different perspective and different roles. I think this is where we need to really start talking about this and rethinking how we approach policy and how companies approach the use and access of this data. If you start thinking about it as being a good custodian with a fiduciary duty to the individuals whose the information is about, suddenly the landscape changes. It's not an asset to be bought and sold, and it's not an asset to be analyzed and used in ways that are unwarranted, to use a term from surveillance. It's really about how are we impacting the individuals ultimately and creating that line of trust. And I think this is where we really need to have an international conversation about this and create international norms, not necessarily laws and regulations, that then can flow into how companies and governments, et cetera, deal with these issues. And we're seeing it right now in Europe with the tension between freedom of expression and privacy, with the extremist content issues that are happening, et cetera. These are issues that are happening day in and day out. And I think not having that international context is truly problematic. It's happening also in the MLAT discussions. If you don't know what MLAT, but that's how cross-border data requests by law enforcement are effectuated. And most of the conversations are happening amongst the US companies because they are the ones being mostly targeted for this. But it's an international issue and problem that affects law enforcement globally and also affects companies globally. And I think having that understanding can really help advance more measured approaches and more thoughtful approaches to this type of policy.
We're going to wrap it up. I'm going to say thank you to this phenomenal panel. Thanks to all of you for the questions. I'm sure these conversations will continue. And enjoy the rest of the reunion weekend. Thanks, everybody.